Hey everyone, Harry here to talk about the latest developments in the lawsuit in the Southern District of New York about whether people from Doge can have access to payment systems and all that information that the Department of Treasury possesses basically to hire and pay federal employees. So a group of plaintiffs came in and challenged that arrangement, and the district court, the same one here, Judge Vargas in Manhattan, said, you've got a good claim here. I'm going to grant a preliminary injunction and rule that you're likely to prevail on the merits, and we will go forward. And that's because it doesn't look as if the Doge people who have now been granted access have gone through the training they need to, the Treasury provides for its employees, everything about, access to sensitive payment systems, whom you can't give them to, what you have to do to safeguard it. That's a significant part of the training of Department of Treasury. These Doge folks don't appear to have it. However, the court at the time said, but I'm not going to preclude the Doge people from actually having access. Rather, I'm going to require, and you'll have to show me, that you're going through all the training and doing all that needs to be done. And this has come up in other cases as well. The legal requirements about access to personal and private data apply to the government, but they don't say that nobody outside of Treasury can have it. They just establish safeguards. So as other courts have recognized, if they do it right, the administration, and they have not done it right, which is why there's a injunction here. But if they do it right, we don't see a legal impediment to people from Doge having this information. Okay. So what the district court reiterates all that, and the actual extra step from that it just granted its order is fairly small. It previously had 4 people from Doge who had said, I'm not going to enjoin them from getting information, but I am going to require they go through all the steps. You show me training and the like. So they are the equivalent of Treasury folks. It's almost like Treasury is hiring a few new people, and they have to make sure that they are, qualified and conversant in what they can and can't do with private information. Now there's someone else that Doge wants to use the information, and the plaintiffs come forward and say, don't modify the injunction to permit it to them to use it. And the administration comes in and says, dissolve the injunction altogether. We're doing what you say. We're going to give training and the like. So you have the court on the one hand saying, yes, I'm going to modify the injunction. I've already said these 4 people can access the information. There's no difference about this 5th, so I will permit it. On the other hand, there's also nothing that really has changed about the administration's position and its need to put into place a lot of formal mechanisms, training protocols, and the like before I could bless their receipt of information. So I'm also not going to dissolve the preliminary injunction. So 5 people instead of 4 are not precluded from looking at information for now. On the other hand, Doge overall is precluded from doing things without certain training and other requirements. And now the case with this preliminary relief established should go, in theory, to trial, where the district court decides, should I take my temporary relief that said, freeze the linebackers and make sure that nothing happens while we try this case, and now go forward and try it and see whether this preliminary injunction should ripen into a permanent injunction. And that's what would normally happen. Of course, it's subject to the administration trying to come up with some sky is falling emergency petition, which it would bring to the Second Circuit Court of Appeals, the court that is above Judge Vargas in the Southern District of New York, and say something like, you have to dissolve this temporary protection and injunction, but would need to come up with a reason that A, they are going to win, because that's the first thing you think about, likelihood of success, and B, the balance of equities rests with the administration. That is basically they're really getting hurt and suffering irreparable injury from having to have their Doge folks go no further than Judge Vargas has permitted them to go. Neither of those claims seems very strong to me, but courts of appeals, different courts of appeals sometimes are more or less discriminating and tight about interpreting the restrictions for preliminary injunctions, which, as Vargas recognized, are supposed to be narrow. But as she said, they are narrow, and I'm letting this other person in. So end of story. Let's go to a trial on the actual injunction. So that's where things stand. And the next move, the ball's in the court of the administration to see whether they will try to now challenge the affirmation or the continued grant of temporary relief to the plaintiffs while they figure out whether the claim is valid and should produce a permanent injunction. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.